There are a variety of ways to promulgate federal regulations. These are described in the clip titled Rulemaking in Quimby's administrative law course. In this clip, we'll examine informal rulemaking, the most common rulemaking process. Informal rulemaking, also called notice and comment rulemaking, begins when an agency issues a notice of proposed rulemaking, or NPRM for short, by publishing it in the Federal Register. An NPRM includes background information, including why the regulation is needed, reference to enabling authority, the text of the proposed regulation, or a description of the subjects and issues to be addressed, notice of a public comment period, including a deadline, information regarding public participation in the rulemaking proceeding, and the designated agency official's contact information. The agency official's contact information appears in a section labeled, quote, "For further information, contact," unquote. It's extremely helpful to have the email and phone number for a specific individual who can answer questions about a proposed rule. In other words, the agency gives notice that it is considering a new regulation and gives interested parties the opportunity to comment on the proposed language. This process is called notice and comment. The final step in the process is to publish the final regulation in the Federal Register. An exception to the notice and comment process exists if an agency needs to issue emergency regulations. For example, if the Federal Aviation Administration, or FAA, has to ground a particular model of aircraft so that all the engine mounts can be inspected for cracks, then the FAA doesn't have time to publish the proposed rule and wait for feedback. In this situation, the FAA issues an Emergency Airworthiness Directive. The Emergency Directive is followed up with something called a Final Rule Airworthiness Directive that is published in the Federal Register within 30 days after the Emergency Directive is issued. So even if the agency skips notice and comment due to an emergency, it still can't get out of the publication requirement. Here is the informal rulemaking process in a more visual form. The proposed regulation is published, that's the notice part. Then individuals and businesses submit feedback, that's the comment part. The comments are collected by the agency, which may or may not revise the original proposed regulation based on those comments, and publish it again for comment. This process may happen only once, or it may be repeated several times. At some point after the comment period closes for the last time, the agency issues the final regulation, or the agency may decide to abandon that particular regulation, never finalizing it. Skilled legal researchers pay close attention to the date when the comment period closes. The agency can issue the final regulation at any time after that date. The final regulation must have an effective date not less than 30 days after publication in the Federal Register. In other words, the agency has to give people at least 30 days to figure out how to comply with the new regulation before the regulation can take effect. Final regulations are published in two places. First, they appear in the Federal Register chronologically, and then they are codified and reprinted in the Code of Federal Regulations by topic. A legal researcher needs to be especially careful. When using the Federal Register, a proposed regulation looks exactly like a final regulation. The only difference is the label at the top of the page. The Code of Federal Regulations, or CFR, is arranged by topic into 50 titles that roughly correspond to the title numbers in the United States Code. The CFR is published on a quarterly schedule so that no section is ever more than 1 year out of date. In both the Federal Register and the Code of Federal Regulations, every final regulation must list two citations: authority and source. Authority is a citation to the United States Code, indicating the enabling legislation. Authority provides confirmation that the agency has the power to do what it is doing. Source is a citation where the final regulation first appeared in the Federal Register. Source is especially useful for the legal researcher because it shows where to look for additional background information about why the agency drafted the regulation the way it did. This is similar to the legislative history of a statute. Here's what authority and source look like in a final regulation. Authority will always contain a citation to the United States Code, or more rarely, a public law, referencing the enabling legislation. Source will always contain a citation to the Federal Register to show when the regulation first appeared. While the U.S. Code citation for the enabling legislation appears in the authority section of a regulation, in most other places, an agency refers to this legislation in its public law form. If a regulation refers to a, quote, section of the Act, unquote, it's the public law, not the U.S. Code. For example, when the Equal Employment Opportunity Commission refers to Section 504, it is talking about a section of the Rehabilitation Act of 1973, not a section of the U.S. Code. Section 504 is found in Public Law number 93-112. The corresponding code citation is 29 U.S.C.A. Section 794. There are tables within the U.S. Code that translate between public law sections and U.S. Code sections, but it's often easier to consult a secondary source. A law review article or treatise discussing Section 504 will usually list the corresponding U.S. Code reference in a footnote. Today we have focused on federal regulations. Most states use a similar process and have a register and an administrative code, in print or online. Now that we've examined how regulations are promulgated under the informal rulemaking process, the next clip will cover how to find relevant regulations and how to update them. But first, stop and take the quiz on regulations and the informal rulemaking process so that you can gauge your understanding of everything we've discussed in this clip.